A bailiff, from Middle English bailiff, Old French bailis, bail custody, charge, office, cf. Bail, based on the adjectival form, bailivus, of Latin bajulus, carrier, or bailiff is a person who applies for bail in countries like India and Pakistan. Another official sometimes referred to as a bailiff was the Vogt, see Vogt and Vogt, Switzerland. In the Holy Roman Empire a similar function was performed by the Amtmann. Name: Bailli, 12th century French bailiff, administrative official, deputy, was derived from a Vulgar Latin term bajulivus meaning official in charge of a castle, that is a royal castellan. British Isles. Historic bailiffs. Bailiff was the term used by the Normans for what the Saxons had called a reeve, the officer responsible for executing the decisions of a court. The duty of the bailiff would thus include serving summonses and orders, and executing all warrants issued out of the corresponding court. The district within which the bailiff operated was called his bailiwick, even to the present day. Bailiffs were outsiders and free men. That is, they were not usually from the bailiwick they were responsible for. Throughout Norman England, the Saxon and Norman populations gradually mixed, and reeve came to be limited to shire-level courts, hence sheriff, while bailiff was used in relation to the lower courts. Primarily then, bailiff referred to the officer executing the decisions of manorial courts, and the hundred courts. Likewise, in Scotland a bailli was the chief officer of a barony, Baron Bailli, and in the Channel Islands they were the principal civil officers. With the introduction of justices of the peace, magistrates courts acquired their own bailiffs. Historically, courts were not always concerned with legal matters, and often decided administrative matters for the area within their jurisdiction. A bailiff of a manor, therefore, would often oversee the manor's lands and buildings, collect its rents, manage its accounts, and run its farms, see Walter of Henley. In the 19th century, the administrative functions of courts were mostly replaced by the creation of elected local authorities, councils. Nevertheless, the term bailiff is retained as a title by the chief officers of various towns and the keepers of royal castles, such as the High Bailiff of Westminster and the Bailiff of Dover Castle. In Scotland, bailli now refers to a municipal officer corresponding to an English alderman. In the 20th century, the court system was drastically reorganized, with the assize courts taking some of the powers of the shire courts, and becoming the High Court. In turn, the remaining elements of the shire court took over the powers of the hundred courts, to form county courts. The High Court acquired the sheriffs, the county court the bailiffs. Bailiffs were now appointed by a county court judge, and were removable by the Lord Chancellor. Delegation. A bailiff could, for practical reasons, delegate his responsibilities, in regard to some particular court instruction, to other individuals. As the population expanded, the need for the services of a bailiff mainly arose from financial disputes. Consequently, these assistants came to be closely associated with debt collection, in the public's minds. By Shakespeare's time, they had acquired the nickname bailiffs, perhaps because they followed debtors very closely behind them. In France, the term pascal, literally push-ass, was similarly used for their equivalent officers. To avoid confusion with their underlings, the County Courts Act 1888 renamed bailiffs as high bailiffs. This act also formally acknowledged the high bailiff's right to appoint, and dismiss, under bailiffs as he wished, and establishing that the high bailiff retains ultimate responsibility for their actions. The high bailiff gradually became a purely ceremonial role, the court's clerk liaising with under bailiffs directly. The Law of Distress Amendment Act 1888 enacts that no person may act as an under bailiff to levy any distress for rent, unless he is authorized by a county court judge to act as an under bailiff. The County Courts Act 1888 restricted the hours an under bailiff could execute a possession warrant, to only be between 6 a.m. and 10 p.m. Section 142. It also limited the ability to bring a legal complaint against a bailiff. 6 days' notice now had to be given, Section 52. Modern-day usage. Channel Islands. In the Channel Islands, the bailiff is the first civil officer in each of the 2 bailiwicks. He is appointed by the Crown, and holds office until retirement. He presides as a judge in the royal court, and takes the opinions of the jurats. He also presides over the states, and represents the Crown on civic occasions. The bailiff in each island must, in order to fulfill his judicial role, be a qualified lawyer. England and Wales. With the 19th century renaming of bailiffs to high bailiff, their under bailiffs generally came to be referred to as bailiffs themselves. The powers and responsibilities of these bailiffs depend on which type of court they take orders from. In emulation of these responsibilities, a number of roles established by 19th century statute laws have also been named bailiffs, despite not having a connection to a court. Magistrates bailiffs. In respect of the large number of petty sessions courts, and the occasional need they had for action by a bailiff, magistrates bailiffs have long been employed on an act-by-act basis, and are now largely organized as private companies, offering their bailiff services to magistrates. They can also act on behalf of local authorities, who have been awarded a relevant debt liability order by a magistrate. The magistrates bailiff companies currently in operation are, as of 2014, Marston Group, Collectica, Excel Enforcement, and Swift Credit. The Blair ministry took exception to the continued use of a number of ancient terms, especially within the legal system. Under Part 3 of the Tribunals, Courts and Enforcement Act 2007, which came into force in April 2014, bailiffs was renamed enforcement agents, and carry a certificate signifying their authority as bailiffs. Certificated enforcement agents. Certificated enforcement agents are used by local authorities, Her Majesty's courts and tribunals service and landlords for a variety of reasons such as collection of taxes, road traffic debts and commercial rent arrears to name but a few. Certificated enforcement agents are also used by local authorities and Her Majesty's courts and tribunals service to carry out the enforcement of both bail and non-bail arrest warrants. This usually involves the enforcement agent locating a wanted person and taking them into custody. It is common misconception that a police officer has to be present to assist the enforcement agent with an arrest. However, this is not a legal requirement and would only be the case where the enforcement agent needs assistance with the arrest or transportation of the prisoner to the court. Where the person is arrested outside court hours, the enforcement agent may take the detainee to a police station where they will be held until the court reopens for business. Enforcement agents must give several days' notice before visiting the debtor's property to take control of goods. In July 2013, Court Service announced it is to fully contract out the whole of the compliance and enforcement process to a private company. This would involve the transfer of over 500 of its employees. This decision led to official strike action by some employees on July 30, 2013.